Hello, I'm Judge Todd Taylor. I'm a district court judge in the 19th Judicial District, Weld County.
And my name's Steve Bernard. I'm a judge on the Court of Appeals.
We're going to talk about 404B evidence. What is Colorado Rule of Evidence 404B? Evidence of other crimes, wrongs, or acts is some of the most powerful evidence a party can introduce in a criminal trial. It also has the potential to unfairly prejudice the side against whom the evidence is introduced. For this reason, the law has developed an elaborate framework that must be used to carefully consider when this evidence can be admitted and when it is unfair to admit it.
It is a rule of evidence that states both a general rule and an exception to that general rule. The general rule is a party cannot introduce evidence of other crimes, wrongs, or acts, often referred to as uncharged misconduct, to show that a person acted in conformity with this other behavior. This prohibited use is often called propensity evidence.
The exception is uncharged misconduct evidence may be admissible to prove things other than a person had a propensity to commit misconduct. Rule 404B contains a non-exclusive list of what these things could be: proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident.
Uncharged misconduct evidence has pros and cons. It may be helpful to prove part of a case. If it is admissible, uncharged misconduct may help the jury in figuring out the truth of what happened in a case, especially as to the elements of the crime or defenses which are hard to prove because they involve behaviors or intentions that are not normally open to observations by others.
But if it is admitted when the rules that we will be discussing are not followed, it presents two risks to a trial's fairness. First, a jury might convict the defendant because of his or her character, not because of the evidence in support of the charge that the prosecution brought against the defendant. Second, a jury may overestimate the probative value of the uncharged misconduct evidence. In other words, a jury might convict a defendant because they don't like him or her based on conduct not directly related to the charges in the case.
For the purposes of this video, we will use an example from a criminal case, which we will describe in a few minutes, in which the prosecution asks the court to introduce uncharged misconduct evidence to prove a defendant's guilt. In criminal cases, it is usually the prosecution that seeks to introduce such evidence, but a defendant may seek to introduce it too, and the court uses the same rules when it analyzes the defendant's request to introduce the evidence. And those same rules govern the admission of uncharged misconduct in civil cases.
When does Rule 404B apply? It applies during a trial's guilt or liability phase.
It does not apply at pretrial, post-trial, or sentencing hearings, when uncharged misconduct is used to impeach a witness under Colorado Rule of Evidence 608B, when a prior conviction is used to impeach any witness, including the defendant, when character evidence is admitted under one of the exceptions of Colorado Rule of Evidence 404A, or if the uncharged conduct was a legal act.
It also doesn't apply when evidence of uncharged misconduct is admissible as res gestae. Res gestae evidence is evidence of other offenses or acts that is not extrinsic to the charged offense, but is instead part of the criminal episode or transaction with which the defendant has been charged. Res gestae evidence is linked in time and circumstances with the charged crime. It forms an integral and natural part of the crime, or it is necessary to complete the story of the crime for the jury. Rule 404B evidence is independent from the charged crime. Res gestae evidence is linked to the charged crime. Rule 404B also does not apply to evidence of other crimes, wrongs, or acts of someone other than the defendant to show why the defendant took some action or had knowledge of some fact.
Before the court admits uncharged misconduct evidence under Rule 404B, the prosecutor must satisfy the four-part test that our Supreme Court set forth in People v. Spoto. Because this analysis can be complicated and it can take some time, the general expectation is that the party seeking to introduce misconduct evidence under Rule 404B, particularly the prosecution, will give the notice before the trial so that a hearing can be held and the court can take some time to consider its ruling.
The test asks a series of 4 questions. 1. Does the uncharged misconduct evidence relate to a material fact? Under Colorado Rule of Evidence 401, a material fact is a fact of consequence to the determination of the action.
2. Is the uncharged misconduct evidence logically relevant to the material fact? In other words, under Rule 401, does the uncharged misconduct have any tendency to make the existence of the material fact more probable or less probable than it would be without the evidence?
3. Is the logical relevance independent of the intermediate inference that the general rule prohibits, which is that the defendant had a propensity to commit the crime with which he or she has been charged? In other words, is the logical relevance independent of the prohibited intermediate inference that the defendant committed the charged crime in this case because he or she had a propensity to commit it? It is the prosecutor's obligation to provide a precise evidential hypothesis that answers this third question.
4. Under Colorado Rule of Evidence 403, is the probative value of the uncharged misconduct not substantially outweighed by the danger of unfair prejudice? Unfair prejudice occurs if evidence, although otherwise admissible, has an undue tendency to suggest a decision on an improper basis. An improper basis is normally, but not always, an emotional one, like sympathy or hatred or contempt or retribution or horror.
The prosecution, as the proponent of the uncharged misconduct evidence, must satisfy each of the 4 steps. In other words, the court must be able to answer all 4 questions yes before it admits the uncharged misconduct evidence. If the court answers any of the questions no, it cannot admit the evidence.
Here is the hypothetical we promised you of how the Spoto test works. Spoto test 1. The prosecution asserts that the defendant is disputing that he was the person who committed the crime in armed robbery. The defendant has raised the defense of alibi. The trial court finds that there is a material fact at issue, the identity of the robber.
Spoto step 2. The prosecution points to unusual aspects of the robbery that is the charged offense. The robbery occurred in a convenience store. The robber wore a black bandana over his face that bore the picture of a skull and crossbones. The robber was armed with a large revolver that had white pistol grips. When he entered the store, the robber shouted, "On the floor, mateys! This be a stick-up. One wrong move and I'll send you to Davy Jones' locker." A clerk followed him out when he left, and the clerk saw that the robber got into a black Honda Civic that did not have any license plates. The robber escapes. The prosecution offers evidence of another robbery that occurred a week later. The robber in that case robbed a convenience store. He wore the same kind of bandana over his face. He was armed with the same kind of pistol. He made the same statements, and he drove the same getaway car. But the police pulled over a black Honda Civic without license plates about 5 minutes after the robbery. The defendant was the driver. The police recovered the bandana, the pistol, and the money from the convenience store when they searched the Honda. The court finds that the uncharged misconduct is logically relevant to the material fact of identity.
Spoto step 3. The prosecution contends that the evidence of the subsequent robbery is modus operandi evidence. Modus operandi evidence requires a high degree of similarity between the uncharged misconduct and the charged crime. The focus is not on the number of similarities, but on their uniqueness. The prosecution then asserts that the evidence of the other robbery leads to the intermediate inference that it is objectively unreasonable that anyone but the defendant committed the robbery in the charged case. The court then finds that the logical relevance of the uncharged robbery is independent of the prohibited intermediate inference that the defendant committed the charged robbery in this case because he had a propensity to commit robberies.
Spoto Step 4. The court finds that the probative value of the uncharged misconduct is high. It is strong evidence that the defendant was the person who committed the robbery charged in the case, and it is strong evidence that disproves defendant's alibi. The court finds that the uncharged misconduct evidence is not substantially outweighed by the danger of unfair prejudice. The court adds that the uncharged misconduct evidence would not have an undue tendency to suggest to the jury that it should convict the defendant on an improper basis, such as sympathy, hatred, retribution, or horror.
Let's talk a little bit about processing Rule 404B motions. As the trial court judge, you must demonstrate in the record that you have properly analyzed the request to admit evidence of uncharged misconduct. If the record does not reflect your careful consideration of the evidence, there is a high likelihood that your decision may result in the reversal of any conviction.
If you are more comfortable applying the Spoto analysis in writing, take the matter under advisement at the end of the hearing and then issue a ruling. This procedure has the advantage of giving you time to fully analyze the motion and then to use a written template to apply all the factors.
If you are more comfortable ruling orally from the bench, then be sure to have a cheat sheet or some other method that reminds you of all the factors that you need to consider in ruling on the motion. This procedure has the advantage of saving the time necessary to prepare a written ruling and allows the parties more time to take your ruling into consideration in their trial preparation and in plea negotiations.
No matter which procedure you use, be sure to cover these issues. First, require the prosecution to clearly identify the proper material fact at issue, and require the defendant to identify whether the defense at trial will contest the material fact the prosecution is seeking to prove with the 404B evidence. Any mistake in not identifying and addressing the proper material fact at issue will infect the rest of your analysis.
Second, do not allow the prosecution to explain the logical relevance of the misconduct evidence by merely repeating the laundry list of the evidentiary concepts contained in Rule 404B. Instead, require the prosecution to identify with specificity how the proposed evidence logically proves the material fact at issue.
Third, based on the prosecution's stated evidentiary concept, identify what facts need to be discussed in the record to justify the admission of the misconduct evidence. For example, depending on the evidentiary concept, some similarity or a great deal of similarity may be required. If similarity is necessary, require the prosecution to explain what those similarities are and where they can be found in the record. On the other hand, if the evidence is being offered to show the defendant's motive, then similarity of the crimes often has no significance whatsoever.
Fourth, require the prosecution to clearly explain how the misconduct evidence proves the material fact for which it is being offered without relying on the inference that the reason the defendant committed the charged offense is because the defendant has a bad character.
If the prosecution is unable to satisfactorily explain how the evidence meets these requirements, do not admit the evidence.
Let's talk about some other procedures. First, Rule 404B requires that, if the defendant asks, the prosecution must provide reasonable notice before trial or during trial if the court finds that the prosecution had good cause not to provide pretrial notice of the general nature of the uncharged misconduct evidence that it intends to introduce at trial.
If the court decides to admit the evidence, the court must give the jury a limiting instruction. The instruction must state that the jury may only consider the uncharged misconduct evidence for the limited purpose or purposes that the court approved when it decided to admit the evidence. And the court should give the instruction twice, once when the evidence is admitted and once in the final instructions that the court gives to the jury before it deliberates. Be sure that the limiting instruction links the evidence to the material fact or facts for which you admitted the evidence.
There are also statutes that apply in two kinds of cases. If the court is trying a sexual offense, Section 16-10-301 sets out some specific procedures that the prosecution and the court must follow when offering and admitting uncharged misconduct. The four-part Spoto test still applies in addition to those procedures.
If the court is trying a domestic violence case, Section 18-6-401.5 sets out some specific rules too. But again, the four-part Spoto test still applies.
If you have time to do research, there are many Colorado appellate cases that have discussed various aspects of Rule 404B. The federal rule is similar, so federal law is also helpful. And Professor Edward J. Imwinkle-Reed's treatise, Uncharged Misconduct Evidence, is an excellent and comprehensive resource. Thank you, and good luck.